Fair procedures matter in a redundancy process. When an employer is considering making an employee redundant, consultation is an important part of a fair and lawful process. Under Irish employment law, if an employer dismisses an employee by reason of redundancy without any consultation, or where the consultation process is inadequate or unfair, this can give rise to concerns with respect to the process followed. If the process is unfair, this can generate concerns with respect to the genuineness of the redundancy matter. Consultations should take place before a final decision is made. There should be engagement. In practice, many employees are presented with a redundancy decision rather than a redundancy proposal. This approach can be problematic. Fair procedures require employers to engage with employees in advance, explain that redundancy is being considered, and allow the employee an opportunity to respond. Employees should be asked whether they can suggest alternatives to redundancy, why they believe they should be retained, and what other options may exist to avoid job loss. These alternatives might include redeployment, changes to duties, reduced hours, or other cost-saving measures. Employers should be able to show that these alternatives were genuinely considered rather than the consultation being a tick-box exercise. The timing of consultation meetings is also very important. If an employer makes the decision to dismiss first and only consults afterwards, this will lead to concerns about a procedurally flawed process. In unfair dismissal claims, adjudication officers will examine whether the employer's conduct was reasonable in all the circumstances regarding a case taken under the Unfair Dismissal Acts. It is also important to be aware that strict time limits apply when bringing claims to the Workplace Relations Commission. At Cleary & Co Solicitors, we advise both employees and employers on redundancy processes, consultation obligations, and unfair dismissal claims. We provide clear, practical advice at every stage, from early guidance through to representation before the Workplace Relations Commission and Labour Court. If you require advice on a redundancy situation or an unfair dismissal claim, you can contact us on 015461121 or 052 612 1999 or email info@clearysolicitors.com.